Okay, good evening everyone. So for this video, I have here the nature of contract of sale. So let's start by the definition of a contract of sale. So by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefor a price certain in money or its equivalent as provided in Article 1458 of the New Civil Code. So, by this definition, you would see the following essential requisites. Of course, we have the parties, right? So, the buyer and the seller, the vendee and the vendor. Okay. So, what about their obligations? No? As to obligations, the buyer is obliged to pay. On the other hand, the seller is obliged to transfer the ownership. Aside from that, let's highlight this term, and to, of course, and to deliver a determinate thing. So it's not enough that there is a transfer of ownership, but also the delivery of the determinate thing, since the delivery makes or perfects or consummates the contract of sale. Here, take note that the contract of sale creates real obligations to give, as being compared to personal obligations. When you say personal obligation, it refers to obligations to do, right? And in obligations to do, the remedy of specific performance is not available. So you cannot force a seller to buy you a particular thing or particular determinate thing. So it's not a personal obligation. The seller is not obliged to give you the item. But rather, the sale creates real obligations to give. And the remedy of specific performance is available. Okay. Now, the essential elements of the contract of sale, similar lang din with any other contract. You have consent, object, and cause, right? Question is, how is it perfected? Okay, how is it perfected? Okay, the contract of sale is perfected at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. Thus, the elements of a contract of sale are consent. So, let's write it here. The elements of the contract of sale, elements of the contract of sale are as follows. You have consent, object, that's object, and price in money or its equivalent. Okay. Now, what would happen if one of the essential element is missing? By the way, take note, question, is it necessary to have these three elements present? The answer is yes. Okay. Since this constitutes, the contract being of existence. So these three elements, these are the very, very basic, right? Very basic requisites of a contract. So you have consent, object, and price in money or its equivalent, or simply the consideration. Now we have wrote here what would be the effect if one of the essential elements is missing. Effect if one of the essential elements is missing. The contract is considered as void, right? Because there's no contract to speak of. And of course, how is it perfected? Yun nga, the moment that there is a meeting of minds. Now let's proceed with the characteristics of a contract of sale. So these are the things that you need to remember, no, for the characteristics. For one, since the perfection of the contract of sale is upon a meeting of minds between the parties, so the contract of sale is consensual. It means that it is perfected at the moment there is a meeting of minds upon the thing which is the object of the contract and upon the price. Take note that delivery of the thing bought or payment of the price is not necessary for the perfection of the contract. Okay? So, when you have negotiated for the sale to happen or to exist, there's no need for you to deliver the thing. Okay? Kasi consent lang eh. And failure of the vendee to pay the price after the execution of the contract does not make the sale null and void for lack of consideration, but results at most in default on the part of the vendee, for which the vendor may exercise his legal remedies. Subject to the provisions of the Statute of Frauds, a formal document is not necessary for a sale transaction to acquire binding effect. So just like when you buy sa Shopee, no, and Lazada, there's no need for the delivery. The sale is being perfected when you accept, since these items are like offer or advertisements, and when you accept the specifications and the descriptions based on what is written, no, in the page. So for as long as the essential elements of a contract of sale are proved to exist in a given transaction, the contract is deemed perfected regardless of the absence of a formal deed evidencing the same. Okay, now let's proceed with the second characteristic, which is a bilateral contract. So it is a bilateral contract which creates what? Reciprocal obligations. Okay. A contract of sale creates reciprocal obligation where the seller obligates itself to transfer the ownership, right? And deliver a determinate thing. So these are the keywords that you need to remember. And the buyer obligates to pay, right? And the buyer obligates to pay a price certain in money or its equivalent. We have already discussed that reciprocal obligations are those which arise from the same cause, no? Same cause, and in which each party is a debtor and creditor of the other. So it's the same. We're referring to the same contract, right? And they are to be performed simultaneously, such that the performance of one is conditioned upon the simultaneous fulfillment of the other. Once the other party have given the payment or consideration, no, the seller is now obliged to transfer the ownership and deliver the thing. So there should be an exchange. Or if it's like a COD, no, cash on delivery, the courier or the the JT Express, LBC, once they have given you your order, you need to pay for the value of the items you purchase, right? So it's a bilateral contract which creates reciprocal obligations vis-a-vis the same item or same subject matter. Now, a contract of sale is normally commutative and onerous. Not only does each one of the parties assume a correlative obligation, but each party anticipates performance by the other from the very start. However, in a sale, the obligation of one party can be lawfully subordinated to an uncertain event so that the other understands that he assumes the risk of receiving nothing for what he gives, which makes the contract aleatory and not commutative. So what would be an example for this? A sale of a ticket, right? Lotto ticket. You don't know whether or not you will receive something from it. Diba? It's like a sale of hope or expectation. commutation. So in this case, this is not commutative but aleatory. Okay. But of course, it's not the usual course of business, hence the contingent character of the obligation must clearly appear. Now, let's proceed with the next characteristic of the contract of sale. So, in relation to the acquisition and transfer of ownership, it should be noted that sale is not a mode, but merely a title. When we say mode, class, ano ba yung ibig sabihin natin ng mode? So, when we say mode, it means, it's a legal means. So, let's write it down. When we say mode, it's a legal means by which dominion or ownership is created, transferred, or destroyed. Okay. And when we say title, it's a legal basis by which to affect dominion or ownership. Okay. Under Article 712 of the Civil Code, ownership and other real rights over property are acquired and transmitted, okay? Acquired and transmitted by law, donation, testate and intestate succession, and in consequence of certain contracts by tradition, okay? Contracts only constitute titles or rights to the transfer or acquisition of ownership, while delivery or tradition is the mode of accomplishing the same. Okay. So take note that in the contract of sale, there is delivery, no? Delivery of the item does not make it, perfect, no? At the time that there is a meeting of minds. But in order for the contract to subsist or to make it valid, there must be a delivery. Therefore, sale by itself does not transfer or affect ownership. But the most that sale does is to create the obligation to transfer ownership. It is tradition or delivery as a consequence of sale that actually transfers ownership. And finally, the last one, the last characteristic, of a contract of sale is what? Let's delete this one. Okay. The last one, bakit ayaw niya? Sige, let's duplicate. Gusto ko siyang i-drag pababa. So, how do we do it? Ayon. Ayaw niya. Sige, lagay na lang natin dito. So, the last one is nominal. Nominate. Nominate. Pwede nominate, pwede din nominal. So, nominate and principal contract. Okay. It is nominate because it has a special name under the Civil Code, and it is principal contract because it does not depend upon another contract for its existence. Okay. So that's it. These are the characteristics of the contract of sale. Okay. So as to essential elements and form. By the way, before we proceed, let's discuss muna sales as distinguished from other transactions. So let's have here sales now. As distinguished, sales as distinguished from other transactions. Okay. Wait, what happened? Ayun. So, sales is distinguished from other transactions. So the first one is from barter. Sales versus barter. Okay. Sales, a contract of sale, you need already, right? I hope you can remember it by heart that it's a contract of sale. One of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. On the other hand, in barter, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. So, ilagay natin one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. By the way, why do we need to distinguish sales from the other transactions? What do you think is the reason why we need to have this particular comparison? For one, you need to know whether it's a sale or not, simply because there are different laws that govern these transactions. Okay, so if it does not fall under the definition of a contract of sale, then the laws on sale will not apply. Okay, so the applicability of the law, whether or not it's a sale. Okay, so the issue there is, can we apply or can I apply the law on sales for these transactions? So you need to familiarize yourselves with the essential elements, its characteristics, and is it similar or is it really a sale or not? Okay, so here, let's go back to sales versus barter. By the contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. So, barter is essentially an exchange of a thing for a thing. Okay? An item to an item. While sale is an exchange of a thing for money or its equivalent. And take note, barter is not governed by the statute of frauds, and that the contract of sale or sales is covered by the statute of frauds. Okay, so I hope you can still remember what does it mean when we say statute of frauds. Now, in the olden times, there are items parang they have already identified that there is a particular form, right? If it's a real property, it needs to be written and it must be like in a public document, no? But of course, if it does not involve a real property and that its amount is less than 500 pesos, so there's no need for the public instrument. Okay, so that's a statute of frauds. How about contract of sales or like sales versus or as distinguished from a contract for a piece of work? Ano naman pinagkaiba ng dalawa? Okay. Here, the contract for a piece of work, contractor binds himself to execute a piece of work. It's a piece of work for the employer, right? In consideration of a certain price or compensation. Okay. Yung sa sale, madali lang. You can imagine it, right? Like you would want to go to the mall and then you find some stuff, you want it or you need it, you buy it. So that's sale. In a contract of piece of work, you are considering the mastery the skill, the reputation, the credibility of the artisan, no, of the artist. When you hire that person, hire him or her to make a, let's say, a piece of work, a piece of art, right? So, if it's a sale, let's say for example, what about if that particular artist already executed or performed that service, so meron na siyang output, right? But then the person anong tawag dito, who contracted him, no, did not push through with the sale or iniwan lang niya sa ere yung artist, hindi niya binayaran, hindi niya kinuha. So, that particular item, when it will be subsequently sold, no, it will be no longer, it will no longer be a contract for a piece of work, but it would fall under the purview of contract of sale. Kasi binili mo na siya not because of this artist's capability, credibility, mastery, the skill. Wala. Binili mo lang siya kasi naka-display na siya. Okay. So, it's contract of sale. It's no longer a contract for a piece of work. So, what would be the test in determining whether the contract is for a piece of work or sale? So, if the thing transferred is one not in existence, no? Wala pa siya. And which should never have existed, but for the order of the person desiring it, the contract is one for a piece of work, not a sale. But, if the thing subject of the contract would have existed, nandyan na siya, and been the subject of sale to some other person, even if the order had not been given, then the contract is one of sale. Okay. But in the end, if you will be faced with a dilemma whether or not it's a contract of sale or a contract for a piece of work, it should depend on the intention of the parties. Okay, so you need to highlight it, no? Let's highlight this one, that we need to call out. Make a call out. But, in the end, so let's highlight this sentence, the distinction between two contracts depends on this is a keyword talaga eh. What's the intention of the parties? Okay. So if you're given a scenario, you imagine yourself, what do they want to achieve? What is their objective? Okay. Thus, if the parties intended that at some future date, an object has to be delivered without considering the work or labor of the party bound to deliver, the contract is one of sale. But if one of the parties accepts the undertaking on the basis of some plan, taking into account the work he will employ personally or through another, there is a contract for a piece of work. Okay, I hope that is clear. Okay. Sige. Now, let's proceed with the next item on the list. Ano ba to? I wouldn't want that here. I want it to be like nakatab. Ayun. Ganun. Ganun lang pala. So, how about sale versus agency to sell? Okay. Sale versus agency to sell. The basis of agency class is representation, right? And one factor which most clearly distinguishes agency from other legal concepts is control. An agent, or that person, agrees to act under the control or direction of another who we refer to as a principal. And in the absence of such control, the contract is not agency to sell, but one of sale. Here, if you can imagine, if you're an agent, you do not own the item, okay? So you have somebody to refer to, no? You need to check whether or not it's acceptable to the principal, no? Parang nagbe-bridge ka lang sa kanila. So the transfer of title or agreement to transfer it for a price paid or promise is the essence of sale. While the essence of an agency to sell is the delivery to an agent, not as his property, but as the property of the principal who remains the owner and has the right to control sales, fix the price and terms, demand and receive the proceeds, less the agent's commission upon sales made. So, in short, if the company retained ownership of the goods even as it delivered possession unto the dealer for resale to customers, the price and terms of which are subject to the company's control, the relationship between the company and the dealer is one of agency. So, it's just that the agent receives the thing to sell it and does not pay its price, but deliver it to the principal, and that the principal will identify how much to sell to a third person. And of course, if he does not succeed, if the agent does not succeed in selling it, he returns it to the principal, right? In the contract of sale, on the other hand, there is an obligation to pay the purchase price. Okay. Now let's proceed to two kinds of contract of sale, right? So, two contract of sales. Ayun. Okay. So we have already discussed the definition of sale, the characteristics of the contract of sale as distinguished from other transactions, and now let's proceed to two kinds of contracts of sale. So there are two contracts of sale. We have absolute. When we say absolute, it simply means that there's no condition. Okay, simple as that. No condition attached. No condition, future and uncertain event. So in absolute, when the contract is devoid of any condition imposed on the passing of title of the thing to be conveyed or unto the obligation of a party thereto. Thus, a contract of sale is absolute when title to the property passes to the vendee upon delivery of the thing sold. Okay. And of course, the second item is the conditional sale. Here, it is subject to condition imposed on the passing of title of the thing to be conveyed or on obligations of a party thereto. So, and the seller retains the ownership of the title, okay, while waiting for a positive condition to happen. Then, the contract is a conditional sale. So, when ownership is retained until the fulfillment of a positive condition, the breach of the condition will simply prevent the duty to convey title from acquiring an obligatory force. And if the condition is imposed on an obligation of a party which is not complied with, the other party may either refuse to proceed or waive said condition. Where, of course, the condition is imposed upon the perfection of the contract itself, the failure of such condition would prevent the juridical relation itself from coming to existence. Okay. I think that would be it under the nature of contract of sale. Okay. So I think this would be the end of video number 1. Thank you, class, and I'll see you in the second video.